today, this morning, is we have a conversation about navigating the pitfalls and perils of parallel litigation in various different forums. And what I will admit to openly is when I was listening to these guys chat about what it was that they wanted to talk, I kind of got like every other word. This is not the area where I am an expert, so I asked Todd Walters if he would moderate the panel, so I'm just up here because of my good looks today. I may have a question or two, and I'll try and make it sound like it's not from a complete novice, but these guys are really the experts on this particular topic. So let me introduce the panel. First, I already mentioned Todd Walters, and Todd is a shareholder at Buchanan, Ingersoll, and Rooney, where he's the chair of the firm's patent office litigation practice and co-chair of the intellectual property section. He's a current vice chair of the patent grant practice committee of the IPO, and he has been a wonderful speaker for us over the years, and Buchanan's a sponsor of the event, so we really thank you, Todd, personally, and also Buchanan as well for your support over the years. So thank you very much for being here. Next to Todd is Cook Alcati, and Cook is at Gardella and Alcati, yep. And which is a new name we just over the last couple months, right?
Days
over the last couple.
Soft launch this week, so we're working out the mobile rendering of our website, and then we'll be officially launched.
Great, excellent. So Cook is a principal there, and he specializes in intellectual property litigation with a particular emphasis on patent litigation, and he regularly represents clients in district courts around the country as lead counsel, and is also a sponsor of the program. So thank you very much, Cook. We really appreciate that. And then next to Cook is Drew Sommer, and Drew is a shareholder with Greenberg Traurig, where his practice focuses on complex intellectual property disputes, and he's appeared in nearly 250 contentious cases in jurisdictions all around the country and more than 125 PTAB trials. And Drew is also sort of a neighbor. We go to the same dog park, and Drew's dog is somewhere on that back wall. So Drew, good to see you.
Good to see you.
And last but certainly not least is Ben Weed, and Ben is general counsel at Ridge. And those of you who aren't familiar with Ridge?
Yes, we got him. We converted him.
This is an authentic Ridge wallet. So if you think you have an authentic Ridge wallet, what I would suggest that you do is you come up and you talk to Ben and let him take a look, because we've had that happen with Gina, your chief IP counsel, was here, and she said, "Well, that's not one of ours."
We will replace it. If it's
yeah. So, and Ben is sort of contrarian here as a patent owner, and he was up until he took over as general counsel at Ridge. He was a patent defense attorney, so he's seen it from both sides of the aisle. So I will step back and I will just kick it over to you, Todd, to allow you to take the conversation where you'd like to go.
All right, thanks, Gene, and thanks everyone for coming today. It's our privilege to have the opportunity to do this panel. When you go to a PTAB conference like this and you hear parallel proceedings, everyone thinks you're going to talk about parallel AIA proceedings, two IPRs against the same patent. That's exactly what we're not going to talk about during the panel today. There are many other types of parallel proceedings that you can have with an IPR or PGR. You can have reissues, you can have reexaminations, you can have district court litigation, you can have ITC cases, and you can have Federal Circuit appeals. And today we're going to touch upon district court litigations, ITC, Federal Circuit appeals, and if we get to it, maybe reissues and reexaminations. The first topic that we're going to get to is to talk about parallel district court litigations with IPRs and PGRs. And you heard Judge Tierney yesterday say that for AIA proceedings, 80% of the proceedings, or over 80% of the proceedings on average, have a parallel district court proceeding. And I'm going to turn it over to Ben, and I have this question, and that is, did AIA really serve its purpose of providing an alternative, low-cost, efficient proceeding to bring down litigation costs?
So I will say for Ridge, we have one major litigation going right now. We've had some in the past. They've settled. We've gotten some good results at the ITC. Our big litigation right now is in Colorado. And in that court, the judges are not super familiar with patent litigation. And as a result, the AIA proceedings are a big risk to us as a plaintiff for a stay. And so I don't think for courts outside of the standard kind of, these cases are going to proceed all the way to trial regardless of what's happening at the patent office. I don't necessarily think as a plaintiff, as a patent owner, as a company that asserts our IP against our competitors with the key goal of getting injunctions, that the AIA proceedings actually simplify things. I think what it does is it risks us having to delay our remedies of choice. And so I think in that kind of setting, it's a little bit unique. I think certainly it's a different situation. I would have told you a different thing a year and a half ago as a defense lawyer working on, computer technology troll defense cases. I would have told you a different thing. But as a plaintiff asserting a small IP portfolio in courts where the judges would love to have an excuse not to try a case, I don't think it actually is all that, I don't think it saves resources all that much, personally.
Drew?
Well, I mean, these proceedings, as they were adopted back in 2011 with the AIA, it was viewed that the district courts were largely going to stay the litigation, right? And I think now the answer is most district courts not inclined to stay at least pre-institution. Central District of California, I know Judge Selna routinely stays pre-institution and basically just delays entering the scheduling order that's going to control for trial really by 6 months, because when that institution decision comes out, some 40% or so get denied, and then you're right back in front of the judge. So all you've done is delay the case. I think it depends on how the parties want to use it, right? And if you have parties that are looking at trying to save money and get the invalidity issues decided, and perhaps are willing to cooperate on what they're going to do post-estoppel, they can serve their purpose, but that's a unique set of facts right there. Where the parties are willing to cooperate in litigation and actually willing to pare stuff down early in the case when they may not know what that case is going to look like at the end.
Cook?
Yeah, I mean, I think Drew's right. It's kind of the rare case where it's actually going to save money. I think, it takes a while to put the petitions together. The district court takes a while to get going, but you're spending money the whole time. And I think it's, for any case that's going to settle, if we're not talking about an injunction, if it's going to settle for real money, you're going to have to get through the IPR. And so it's sort of a toll along the way to trial. I don't know that I think it actually it was good for lawyers, and it drove up litigation fees, ultimately.
Well, I think, too, that it's a rare case, at least in my experience, where you have actual, relevant, good prior art, that's product prior art that's not subject to the IPR estoppel anyway. So we deal with a situation at Ridge where there is an allegation of a on-sale piece of prior art out there, which, if it's prior art, is the best piece of prior art. So there's this issue of, is it prior art? They have to prove it up. And we've been up and down at the federal circuit on this issue. So if you have that situation too, the IPR picture gets a little bit different, because you can deal with the estoppel, you can take the estoppel, and our defendants have taken the estoppel because they know their best prior art is this product prior art, and it's all about prove up of the prior art. If the prior art is prior art, it's a problem for us. So that's another kind of a rare situation, at least in my experience, where you have really good potential product prior art that wouldn't be subject to estoppel. So the IPR would just then be a first bite of the apple, and the second bite is just as good. The issues are different. The tricky issues are different, but there are, it's a very good second bite at the apple.
So before we go further, why don't you answer the question as well, from your perspective? What do you think?
Yeah, unless you can get an early stay in the litigation, it only drives costs up in every case. You have to deal with the drafting of the petition, the patent office proceedings, while the litigation is going on. It just increases costs.
Do you think that the outcomes are different ultimately at the end of the day? Do we get, so in other words, do we get to a better outcome, or is it just purely this is driving up costs?
Well, I think people look at the statistics differently. I think you have a different view of the statistics than I do. I generally think that if you compare district court statistics with patent office statistics, they're not that far off. But I know a lot of people just look at the percentages of wins at final written decision after there is a trial. People would say if you go to the patent office and challenge validity, you're going to be much more likely to prevail.
Yeah, I would like to sit down with you sometime and others who might be interested and see if we could come up with a way to look at because the statistics shouldn't be so different. We should be able to like compare closer apples to apples, I would think. But that's a different conversation for a different day.
I mean, I do think it's definitely the case. It's easier to convince the PTAB a patent's obvious than a jury. I think at the end of the day, the judges on the PTAB are more inclined. They understand obviousness. I think a jury is kind of looking at it like you've got these 2 or 3 pieces of paper. You're going to combine them in this hypothetical, conceptual way. I think it's hard to see how it's not easier to show a patent obvious to the PTAB, and there's obviously the burden issue too.
Well, yeah, I think juries are loath to take a piece of property away from a patent owner. I think they like the seal on the front of the patent.
Yeah.
And that's why, as a patent owner, I'd rather have it be in front of a jury all day.
Yeah, and I do think that it complicates your trial theme generally to have both invalidity and non-infringement. I know it's a traditional thought that, we're going to put the squeeze on. Well, it's usually the defendant that looks like they're talking out of both sides of their mouth, not the plaintiff, because that seal is on the patent. So, you could make a litigation call very early on in the case and say, look, I'm going to go to the PTAB. I'm going to use my paper prior art there because I have this trial theme on non-infringement that's clean and understandable, and I can articulate that to a jury. Whereas if I got to talk about this prior art, which is impenetrable, and I'm going to convince a jury that I'm right on how to combine that through my expert, you're walking uphill on that. So, I do think that the PTAB at least may provide an offshoot for the more complicated issues that might muddle a trial theme, especially when you're in like a court like Texas where you got 5 days to try it.
There's a question?
Yeah, do you find that the estoppel provision is being applied in a difficult way? It seems like there's a split among district courts as to whether, when you're talking about system art or product art, if it's cumulative of what was presented at the PTAB. There was a case early in Delaware that said, okay, if the system art is cumulative, that's subject to the estoppel. Then there was a decision by Judge Bryson sitting at the District of Delaware, where he said basically, the estoppel is based on the form of prior art, and therefore system prior art, even if it's cumulative of what's presented at the IPR, is not subject to the estoppel. And that's like at the end of 2023, I think. And then there's been some Eastern District of Texas judges starting to follow that line of thinking as far as the estoppel. And that would seem to truly give the defendant, a second bite of the apple.
So we have estoppel on the agenda, and why don't we take up estoppel now and address that? And Drew, why don't you give the landscape?
Yeah, I think you're absolutely right on your recounting of the history of this. And I think the majority of district courts that are looking at it today look at whether the contention is immaterially different than the paper prior art that went before the office. You've got to remember, if you're going to use system prior art, you have additional proofs to make in district court, like was there a commercial offer for sale, was it ready for patenting, whatever those facts might be, was the use experimental, all of those things kind of layer on that are not at issue at the PTAB. But if I'm representing an accused infringer in district court, one of the things I'm looking at is how different can I make this look from, the manual, right? Or some user guide or programmer's guide. Because, if you're just going to rely on that, I think most of the district courts are saying, yeah, that's immaterially different than something you could have put in front of the patent office. We're going to find estoppel. And I think that's carried over into decisions in 2024 as well.
Well, I think that's especially the case, too, if you're asking the judges to say, let's stay this case while you proceed in the PTAB. They're not going to let you then come back and say, well, here's something that's very similar to what I asked you to stay the case for while we went to the PTAB. Now here's another thing that's another, I think judges are looking at it and saying this is a second bite at this apple, and we're not going to let you have it if it's that close. I think the stay request makes it harder to say a piece of prior art is not cumulative and therefore should not be subject to the estoppel.
Yeah, I mean, I think if there's some feature that you can't see in the manual, like Drew said, and you can cross-section the product and you can see it there, well, I think fairness would say, well, maybe you should get that second bite at the apple. You could make an argument that you shouldn't, but I could see that being the situation where there's something hidden in there that you just can't get at with the paper.
Well, we're on estoppel. Let's talk more about collateral estoppel.
Yeah, so this is kind of the hidden form of estoppel. If you look at the AIA and you're saying, well, there's this estoppel, right? And you've got section 315E1 and E2. So patent owners, you're estopped at the patent office, and same with petitioners, but then petitioner, you're also going to be estopped in district court or the ITC, right? But there is another form of estoppel that the Federal Circuit has somewhat routinely been applying, which is collateral estoppel, to find that patentably indistinct claims that either may not have been challenged in a particular IPR proceeding or perhaps were unsuccessfully are unpatentable under the doctrine of collateral estoppel. There was a case last year where a patent owner had actually amended the claim successfully to add limitations in a dependent claim that the Federal Circuit ultimately reversed on. So the Patent Office had concluded that the petitioner hadn't found that claim to be unpatentable. So patent owner liked its chances, amended its claims, incorporated that in substitute claims. The Federal Circuit reversed as to the dependent claim and sent it back to the PTAB and said, now you need to consider collateral estoppel in light of my ruling. So what you've got is circumstances in which if the elements of traditional collateral estoppel apply, patentably indistinct claims, the same issue has already been litigated, you're looking at not just claims within the same patent or substitute claims, but also claims in related patents with similar or the same disclosure being found unpatentable under the doctrine of collateral estoppel. And the interplay between that and litigation estoppel under the statute is kind of mystifying. How could you possibly argue, if you're already estopped under the statute, how can you argue collateral estoppel along with that? Because aren't you in effect saying that it's invalid under the prior art that you're stopped from raising? So it is a difficult question, and it comes up, and it can come up for the first time even at oral argument. That Zyzel case I was mentioning on the substitute claims, it came up during oral argument, was raised for the first time, and that was because the Federal Circuit decision didn't become final until they wrote it, right? So you didn't meet the finality, but then the Federal Circuit issues its decision, and they're like, it's final now, so consider it on remand.
Cook, anything on collateral estoppel?
Just more landmines for the patent owner.
Yeah.
I don't see it meaningfully hurting the petitioner so often. So.
Yeah, right. It's not going to hurt the petitioner. It's another issue that's got to be litigated in the district court or at the Federal Circuit or in terms of the PTAB applying it. I haven't seen them. I've seen them invited to be applying it, and then they decide not to. So I'm unaware of any PTAB decision that applied collateral estoppel in the first instance, rather than when the Federal Circuit is telling them that they need to consider it.
Well, and to me, too, this new fee increase might be an interesting spot where we see this happening more. Like, we see petitioners relying on the possibility of collateral estoppel rather than filing a $60,000, filing fee petition. You get one that goes your way, and then the rest of the family could be, arguably invalid under collateral estoppel. We may see more of that with the higher fees, right, coming forward.
So I want to move on. One of the things that's most important to me is to give the client some predictability about what's going to happen in a proceeding. And we were all talking this morning about Fintiv. And if I go back historically, before Fintiv came out, you filed petitions, then Fintiv came out, and you're like, where'd this come from? And then we get a new director, and you file petitions under Director Iancu. Now you have a new director, and now there's kind of different rules for the game. Now Director Vidal is gone, and we're going to have a new director, and we're filing petitions today. What's going to happen in 6 months when you have your institution decision, and how do you tell your client that the rules of the game keep changing? And Cook, maybe you can just talk about the landscape and where you see us going with this.
Yeah, I mean, I think if you're filing petitions now, the conservative thing to do is to assume we're going to go back to more like, Director Iancu's version of Fintiv. I think it might be kind of risky to rely on the guidance that Director Vidal published. Yeah, we'll get you to take comfort in that, right? Because I think it probably will change. I mean, I have my own views on what I'd like to see change, but I think it would be a safe bet if you're doing a petition to try to appeal to Director Yanko's version of Fintiv rather than relying on as it stands right now. Do we have a question?
Well, just a comment. We've actually seen a number of Fintiv grants over the last month, really.
Yeah.
So I don't know. It's anecdotal, but these are things that other adult would not have.
Right.
Get killed under Fintiv. We've seen several decisions like that.
What do you mean by a Fintiv grant?
Non-institutional.
Ah.
Right. These are things that under Yanku maybe would have, under adult would not have one on Fintiv.
Yeah, and I think you saw after the ComScope decision, I think Fintiv went up as well once she clarified that you still have to go through the analysis. So, and then I think if you're a patent owner right now, you kind of hope for the best case scenario with Fintiv, that it's going to be more discretionary denials. I think, you want to think about, if you're suing, things you already would have thought about anyway, like venue in terms of stay, how quickly you get to trial. I mean, you were going to try to choose the venue, you could do that anyway, but I think it'll help with Fintiv. And I guess, wish list, I think the whole Sotera stipulation to get around Fintiv, I would like to see that go away. I never found that to be all that fair. I mean, you're taking on estoppel sooner in theory, but it's a statutory estoppel, and oftentimes once you get institution, you're getting a stay anyway. So what are you really getting out of it as a patent owner? I think that would be a good thing to trim back personally.
Ben, as someone asserting patents, what's your thought?
So this is an interesting issue to me, because I think that, where I come from these days is I want to get these things to trial. We want to get to a spot where we have leverage over the defendant, and that happens because of trial. So things like claim construction happening, in the district court case before the IPRs are filed, I think, to me, I'd rather have the IPR, either the defendant take a position early, file an IPR early, let me see your art, let me see your arguments, let me see your claim construction positions early. Or if we're going to get all the way through claim construction and you're going to file the IPR at the end of the 1-year period, as a plaintiff wanting to get to trial, I don't mind that it's harder for that to get instituted. So I personally like the idea that a defendant needs to pick their strategy and their position earlier in a case as a plaintiff asserting patents looking for injunctive relief. So I don't mind if we go back to sort of a Fintiv world where if you're going to get punished a little bit if you wait. I like the idea of the case becoming more clear early, or if you're going to wait, then you gamble on maybe it won't get instituted if you wait.
And I think from a patent owner's perspective, there are things that you can do if you know your court's schedule and it's predictable. A recent technique that I saw used very effectively in East Texas, usually you get the complaint in East Texas, you serve it 20 days, okay, you get a 45-day extension as a matter of course, so you're really not getting to the scheduling conference until 4 months in. Well, you can also amend your complaint as a matter of right. Yeah. So what I've seen is, it's a one patent case all the way to the day before the scheduling conference, where you're going to get this form order from Judge Gilstrap setting a trial date that's the same as everybody else that's in the courtroom, right, for some date 14 months down the road. Well, what was one patent complaint is now a 5-patent complaint the day before the scheduling conference, and you haven't dinged your trial date. So now they've got 14 months, right? So you're going to have a Fintiv issue right there just off the bat because you didn't show your full hand when you initially filed your complaint. And so I think patent owners are adapting to the timing issues and finding ways around them.
But I think if you're a defendant in that scenario, that's like to me, I always thought it was a sort of second shot on a defense if you try the case first and then you have these IPRs that are still pending. I didn't mind that as a defendant because you have a better burden of proof. You have a body that is willing to invalidate patents. I never minded the idea that my IPRs might be decided after the jury verdict. It's tough for clients to get that through their brain, right? Like it's tough to say you might have a judgment against you that might be upset by IPRs, but I never minded the idea that my trial strategy could be whatever I wanted it to be as a defense lawyer, and then the IPRs was sort of like a backstop a little bit.
Well, we saw that actually in the Eastern District of Virginia with Facebook, and they ran into problems where they actually won a verdict on invalidity, and then ran into estoppel 4 months later when the patent office reached the final written decision. So now you've got, well, what does the court do with that? You're stopped. There's JMAL motions pending. Do they need to say, well, as a matter of law, you can't maintain this invalidity defense even though you won it in front of a jury?
Yeah.
So, and that issue actually went up to the Federal Circuit and they punted on it because they affirmed as to, or maybe they reversed, but they found non-infringement basically in that case. But that is a live issue. Yeah.
Yeah, what Ben talked about in terms of, as a patent owner, that's the traditional strategy that we pursue. Go ahead and file.
Yep.
And we've been down in the Eastern District quite a bit. The district court trials are very expensive versus the IPRs. And we ended up with a lot of cases where we've gotten very large jury verdicts as well as validity findings. And then a year or two later, boom, the IPRs hit and basically hollow out that verdict, right? So if there was injunctive relief, I think that would be a good strategy. But in terms of just the dollars that go invested and are put at risk going through that trial, and then you have the underlying patents at risk through the IPR, I think the strategy now is almost reversed. Can we get the results out of the IPR before and have the case filed of state? I mean, that's almost, as a patent owner, that's what I'd like to see.
Yeah, and so before I left the law firm, I was doing a bit of work with litigation funders who had that exact view. It was like, we'd rather have the IPRs proceed because it'll our investment will be more efficient that way, right? Like, let's get the validity determined. Let's spend less money to do that. And if they are valid, if they aren't invalid at the PTAB, let's try the case. The settlement's going to be better, all that kind of stuff. So I think, again, it's an issue of what the patent owner wants. Do they want injunctive relief? Do they want it fast? Or is it a dollars and cents issue? And if it's dollars and cents, I think there's definitely efficiencies to seeing what the patent office does with the patents. But that's a hard thing to convince a client who's paying for it themselves, right? Like, it's a hard thing to convince a client who's saying, these are my crown jewel patents. I want you to assert them for me. And I'm saying to that client, okay, let's see if they're valid. Let's do that first, where you don't have any chance to win. A win is a non-loss at that point, right? So a lot of it to me is sort of client management and sophistication of the client. And for the smaller companies where the patents they don't do this all the time. But it's really their technology, and there's sort of like sweat equity in the patents. It's a hard sell to say to them, let's see if the patent office the second time around agrees with what you saw the first time around when they examined the patents, and let's see if the patent office still thinks they're valid. I think a lot of it comes down to a client management issue, client expectation management issue.
Well, without injunctive relief, you're just looking at the statistics, right?
Sure.
And, with a lower standard of review at the PTAB, and the rate of the petitioners winning there is much higher, or patent owners losing is much higher. So you want to see that, you want to get clarity from that before, but the other side is, okay, do you want to put your patent at risk?
Right.
And will the infringer or the implementer, would they want to sign up after the district court?
Well, a jury verdict is an awfully big settlement lever. I mean, that's that. At the end of the day, if you have a jury verdict in your favor as a patent owner, that's going to probably settle the case, right? Unless the patent owner itself is very greedy, that's a very big lever to have. So I think a lot of times it's just about timing. Where do we get to first? Do we get to the judgment first, the jury verdict first, or do we get to the patent office, result first? And again, it's just, to me, it's like if you're a plaintiff patent owner in the business of asserting patents, then yes, efficiency says, let's see if the PTAB agrees, they're still valid. But if you're, if it's a family business, if it's whatever, it's a small company, like if it's Ridge, we have only a couple of sort of core patents. We want judgments, we want jury verdicts before the patent office gets their teeth into it.
Well, and I think part of the problem you run into is when petitioners wait,
Yeah.
right? And you've
Yeah.
already invested $1 million
Yes.
to get to that point. it's harder to convince a client that, I know you spent all that money, it might be for naught.
Right.
There's nothing you can really do,
Right.
right?
Right.
Some judges will ding you, and that's where Fintiv
Right.
could come in and help. If you wait, then there's going to be consequences, and I think that's fair from the patent owner perspective.
Well, and so another thing, and this is actually a question for you guys. I don't know what you've seen recently, but it's always interested me that, patent owners a lot of times will put their full arguments into the preliminary response, sort of preview what the patent owner response looks like. And I don't like that approach. I personally like to just sort of take the shots at discretionary denial, claim construction issues, things where it's a kill shot type of argument and not preview your merits arguments. But that's also a hard thing to convince your client about or your patent owner about, which is, we're going to hold some arguments back for if they institute. But I think that's a way where for a patent owner, you can make the whole process more efficient if you hold your arguments back, you don't do a declaration, you don't pick apart the obviousness combinations, because the board is going to find there was enough there to institute anyway. If you can convince the patent owner client that that is the way to go, I think that does make it more efficient. But again, it's a hard thing, it's a hard sell. It's like they don't want it instituted at all, because if it's not instituted, it's not appealable, and we move forward. So that's actually curious what you guys have seen in that regard. Have patent owners been filing sort of the fulsome patent owner response, preliminary response that looks like what the POR will eventually look like?
We see that a lot. My personal view is you should be attacking the prima facie case, that something is missing from the petition, and not present issues of fact that should be weighed during trial. We have at least one judge and one former judge out there that I see. I'd be curious, Judge Hoppola, in responding in the patent owner preliminary response, is it good for the patent owner to pin it in all their arguments, or how do you see that?
About a third of our cases are denied institution. If you have a strong case where something's missing, I would point that out, because I think a third of the cases being denied is if it's stats for patent owner to present good arguments.
Yeah. I mean, I think when you're a petitioner, if you get one of those omnibus patent owner responses, it's sort of a gift for depot prep.
Totally, yeah.
Right?
Completely.
You've got the roadmap, you know where they're going to go on motivation. You can really prepare your expert very well to defend it. Whereas if you're more sniper shots, I think you're right. If an element's just missing, then you're kind of foolish for not pointing that out. But I think if you go really beyond that, you're just setting the other side up to have a bulletproof expert at depot time.
Yeah, I agree with that. Generally, I don't put in all of the arguments into my patent owner submissions. It's kind of a waste of breath. I mean, certainly if you've got to support your side with an expert pre-institution, I wouldn't recommend doing that, just because you are totally tipping your hand and you're giving the other side an extra several months to consider what your expert said, and then even get in there and really get their expert lined up to rebut that. Yeah, but I do see it both ways, and I think, for the patent owners that go, full bore and say, I'm going to even pop in an expert declaration to rebut something your guy said, I think that's probably, that's kind of a point that's problematic in and of itself.
Occasionally, there's situations where the petitioner did not meet an element, and you need an expert to point that out. There are occasional situations like that. I had the privilege of working with Judge Moore now as a colleague. I'll let him respond to this topic as well.
Well, I would say if your expert does nothing but muddy the water, it's not absolutely crystal clear, it's a close call, you're going to tip the judges over into thinking it's time to have a trial to resolve this issue with that. And I think it could actually substantially hurt the case again.
Yeah, the important point is you have to knock out all the claims, right? You can't have an argument for a few claims and not address some other claims, because if even one claim is found potentially unpatentable, they're going to answer.
That's a really good point. Generally, when I'm looking at patent owner preliminary responses, I'm only addressing the independent claims, because I need something from those independent claims that's missing. If you're getting into the dependent claims, you're already going to have a trial, because they only have to institute on one claim.
Yeah.
I had seen a series of board decisions that after, they're post-SAS decisions, that said, well, you've really only shown 1 or 2 of these claims, but you want trial on 20 of them, why am I going to undertake that burden? And then you get a discretionary denial saying, look, the juice just isn't going to be worth the squeeze here. Are those types of decisions still common? I haven't seen one in a while.
I have not.
Yeah.
Yeah, I have not.
Okay.
Yeah.
Yeah, I have seen some benefit, actually, though. As long as you've got arguments for independent claims in the popper, arguing some dependent claims separately, the idea being that even if the board institutes, it's going to raise some questions in the institution decision about the viability of the challenges to the dependent claims, which then can be leveraged in district court to fight off a stay motion, show a lower likelihood of simplification. One trend I've been seeing is that district court judges are actually reading institution decisions a lot more closely than they used to. And while not trying to speculate as to what the PTAB is going to do, they will take what the PTAB is saying at face value and factor that into their stay decision. It's not so much binary institute equals simplification anymore.
Well, I think there's value to educating the panel about the issues. I mean, if you sort of assume it's going to be instituted, there is value to putting your positions in front of the panel and saying, we're going to show you this when we get to the trial. And, because obviously the institution decision is the first sort of substantive weighing in by the panel. If you don't put the issue in front of them, they're not going to know it's an issue when it comes time for the hearing and for the final written decision. So I think there's value to that, but I think the problem that patent owner clients have is we don't want it instituted at all, right? We don't want to assume it's going to be instituted and deal with it from there. And that to me is the uphill battle.
Yeah, and that's why you'd only do that if you had viable arguments
Right.
for independent claims as well.
Right. I mean, you could always, again, this assumes a lot of sophistication on the part of the patent owner, but you could always waive the response. You could just get it instituted, hide your arguments back. You could do it quicker than the 3 months, and you could accelerate things if you wanted to. So there are ways to do it, but I have not seen patent owners be that willing to commit to sort of like, okay, it's going to be instituted. Let's deal with this after institution, and we'll take sort of take our lumps on institution.
Can I ask a question along these strategy lines here? So do we know how many of the 1/3 of cases that don't get instituted, how many of those patents wind up ultimately eventually being instituted in some other request? And I raise this because I think it would dramatically, or it should dramatically affect your strategy, I would think, because I understand right now the way the law is that every defendant has a right to challenge. You're being sued, so you have a right to mount a defense, and the defendants always say, well, that's only fair. But when you look at it from the patent owner's perspective, how many times should a patent owner have to prove that this patent is, and in the next panel we're going to have an example of where they did it over and over and over and over again, and then like one time later on, after having done it 6 or 8 times already, then it got taken away. And it's like, well, how many times should a patent owner have to prove? Because if this was trespass, if this was real property, you'd have to do it once. You wouldn't, the next person who stepped foot or walked across or violated your easement or whatever, it would be a pretty quick case. You wouldn't go back to, well, where's Mrs. Wilson's tree and where's the pile of rocks, and relitigate it moving forward the way that we do. So do we know that? Do we know how many patents are ultimately challenged?
There are statistics on serial petitions of the same patent, and those statistics show that those numbers went way down over time. I don't know the exact numbers. Maybe Judge Hapola has access to that she could pull that up real quickly. But the numbers of a second petition, serial petition, has gone down, and then a third petition has gone way down, and then a fourth petition has gone way down after that.
So let me just, make sure we're talking the same language. A serial petition, would it be like the same challenger challenging the patent over again and over again? Or is it like any challenger?
Any challenge.
Okay.
I mean, I do think from the district court perspective, if you've got multiple defendants you're going after and you get a good non-institution decision, we have had conversations like, well, do we really want to sue that next defendant right now? To just open this patent back up to IPR, or do we want to get through the first case with this non-institution decision, get to trial, and then face the IPR? So I do we at least factor in when we're looking at multiple defendants infringing. Do we really want to tempt fate if we've got a good non-institution decision and launch another suit, or do we want to get through this one first, which can be frustrating for a client, especially, I mean, if you're looking for an injunction, you kind of have to go. But if you're okay with damages, it might make sense to take that non-institution decision and not put it back in the crosshairs for someone else.
I think you need to drill into those statistics too to see what the basis for the denial was, because I've seen a lot of Fintiv denials that are then recycled by your next defendant up who may not have those same, pressures of district court litigation. Maybe they're even in a different court and don't have a trial date scheduled or something. So, I think you'd have to peel those statistics back and dig a little deeper as well.
And that's what I think makes this tough when you're talking about the statistics, because all the situations are quite different, and there's a great difference in this case when you're talking about what goes on in parallel or close to parallel or concurrent, or however you want to think about it, between what goes on in the Northern District of California versus the Eastern District of Texas or the Western District of Texas.
I think we had another question out there.
Yeah, just following up on your question about the statistics, Gene. So the PTAB, in their roundup data that's on the site, they report the institution rate at 68% in 2024. And then on a per petition basis, on a per patent basis, the institution rate is reporting at 74%.
Mm-hmm.
So I imagine it could be multiple petitions within a single year. So that's basically 75%. So if you add in, if there's another petition, that number goes way up. The effective institution rate comes to.
Yeah, so there is a delta. It's maybe not as high as I thought it might be, but there is.
I am curious, Gene, why you would think maybe the fifth accused infringer shouldn't have the same opportunities as the first to challenge the patent.
Well, no, see, and this is what I mentioned yesterday about the linguistic thing, right? When you phrase it like that, there is a right answer, right, to that question. It's like, of course, it would be fair to just let them do it, right? But let me flip it back. Why do you think the patent owner should have to prove 5 or 6 times that the patent is valid? Because they've already been given a patent that is supposed to be presumed valid. So this is the problem. I see it from both ways, and I guess what I would just really like, and I think over time, because look, we're still talking about a tribunal that is it's not maybe infancy, but it's a teenager, right? I mean, we've only had it for 13, 14 years, right? Yeah. So, but I would like to see us get to the point where there is a lot more discernment by the judges to try and pick off the patents that are really the bad ones. Or what would be even better would be, let's pick off the bad actors, the patents of the really bad actors, because that's the big frustration I have is the bad actors are asking for so little money that it's just, you just pay them. So if you have a crappy patent and you only want $25,000 for it or $50,000 for it, that patent never gets challenged, and it gets paid and people make money, and it's just extortion. You have a really good patent, a lot of money at stake, that's going to get litigated for a very long time. And I suppose in the system we have, there's just no way around that. But I would like to try and solve for that. So I'll tell you, I'll throw out what I've said many times. What I would love to see is sort of like a quieting title kind of situation where it's, look, we're going to institute this patent. If this patent matters to you, you have 180 days or however long to join in, and come on. If you don't join in, I would default primarily to say, well, then you can't challenge it. Now, I'm not sure that strict draconian rule would be right, because I also understand that some of the patent owners that operate at the edges will then look at the patent and interpret it to try and apply to things that clearly, 98% of us on the face would say, well, that patent was never intended to cover that. So we need to solve for that bad actor as well.
I don't know that you need to say that, that's limited to people that operate on the margins or stretch the patent. Mm-hmm. You can look at a claim 10 different times and appreciate different nuances in it over time. and perhaps applicability, like, you assume something is actually in the claim and you look at it really, really closely and you're like, well,
It's not there.
maybe it's not there.
Yeah.
Now I can go after this party, and that may be years later. So, that's kind of where I start to struggle with the whole idea of, well, title is now permanently quiet and we've got to go to a jury and jury only. Because then you've got patent owners that'll say, okay, I need to find where's my preferred embodiment being used, right? That's the easy case, right? But then you've got the cases where you can start to stretch the claim, not necessarily nefariously, right?
I just find it odd that we have, with trademarks, after 5 years, it can become incontestable. And that doesn't mean that you can't challenge it for anything, but you lose a lot. And that's a piece of property that could last literally forever if it is in continuous use. And here we're talking about an asset that you're never going to get more than 17 years from, realistically. And if it's pharmaceutical, you're probably going to get 12 to 14 years, maybe even less. And at no point in time during that very limited time does the patent owner actually really confidently own what the patent office granted. So that's why I get bothered by it, And and I can't say I have the greatest answer, right? This is why it's frustrating. Judge Tierney was here yesterday. When we talk, we fight like cats and dogs about this back and forth, because I think every perspective has got to, like you should, right? I mean, why can't I challenge the patent, But at some point, it bothers me.
Yeah, well, I mean, if it's the same art, that's kind of an easy explanation. You shouldn't be able to use the same art, but then someone's going to say, well, my lawyers are better than your lawyers, or I have an expert who's more on point. So, it is kind of a tough thing to solve.
So do you think that the as AI gets better at finding prior art and maybe helping examiners and helping you all in your searches, validity and invalidity searches after the fact, that will lead to more people buying into some kind of quieting, perhaps?
I think right now, Drew and I talked about this yesterday, that the examiners have limited resources. They can't spend hundreds of hours trying to find the best prior art. But when the issue comes up for us, sometimes we can spend whatever we want to go find that good art, and there's almost always better art out there. And AI might just help find that better art and have more cases that are challenged.
Yeah, or it could swamp the examiner, right?
Yeah.
You just have this flood of stuff that now you have to apply judgment to. Those applications, so I was a patent examiner many years ago, and when the applicant's IDS would show up in boxes, that's when you knew you were really not going to read it, because I had 21 hours to get through the whole case. So, the MPEP doesn't require me to read it. I have to consider it, I think, Gene, you said this yesterday, as if it's in the shoe case. You start leafing through it, you look at some abstracts, titles, and if it piques your interest, then you start reading the abstract and you say, okay, do I need to dig into this further? You don't need to consider it as an examiner beyond how you consider anything in the same class or subclass.
So one of the questions ended with the comment of the PTAB decision coming and upsetting the district court, and what the district court would do. And one of our topics for the panel is kind of the preclusive effect of the PTAB decision and the intersection with Federal Circuit appeals. And it's pretty clear now that a PTAB decision itself is not preclusive on the district court. You really have to have that PTAB decision appealed through the Federal Circuit and get a decision from the Federal Circuit before the district court is bound. For that reason, it's good to figure out what the timing is on appeals, because if your district court decision goes to the Federal Circuit and is final before the PTAB reaches its decision, the PTAB decision may have no impact whatsoever on the district court decision. And I'll just throw it out there to you guys to see if you've seen this, and and how it impacts your decision-making.
Yeah, I mean, so the firm that I was at before I was at Ridge was the firm that handled the Baxter-Fresenius case for Baxter. And so I was a baby lawyer at the time, but that was a race to final judgment. And so since that time, it's been very clear to me that that is the issue, right? You got to get to a final judgment in the place where you want to have a final judgment. So what I had been advising clients about at the PTAB was, look, if we want to have a final district court judgment, let's argue on appeal things that might require a remand. We'd rather have a remand than a reversal because you get to final, either a reversal or affirmance because a remand delays the final judgment. So it certainly is a strategy, and I think, again, back to my point before about, in my experience, patent owners, they think the jury verdict is the end of the day. It's not. You have to make sure that they know that that is a step in the process. It's a big leverage step, but really a final judgment is what you're after, and there are points you can make to try to delay it one place and get it quicker in another place. It affects, I think, your district court appellate, strategy. Maybe you don't appeal every issue because you want to have a final judgment affirmed. If you lose a damages, claim, for example, maybe you take your damages that you got and you don't appeal that and maybe get a remand and a retrial because it'll take years, whereas you're trying to beat that, patent office finality. I think it's definitely a thing that clients have to be advised about, and they have to understand the jury verdict is not the end of the day. This is still a lot of work to do after that point.
Yeah, I mean, things get really complicated when you run proceedings in parallel, right? And so, to the comments of the gentleman over there, maybe it's better to just sit and wait to see what happens at the PTAB before you invest a significant sum in the case and getting that jury verdict. If you're going to be playing race to judgment at the federal circuit and you get a PTAB decision sometime in the interim, it could unsettle your judgment. And the way that the federal circuit is moving these days, which is very, very slow. I remember coming out of the pandemic, they were actually on top of their backlog, but now they're renovating, I believe they're renovating the electronics in the courtrooms. And so they're down to 2 courtrooms at any given time. And there's a backlog of cases that just keeps growing. Used to take about 10 months to 12 months to get a PTAB case through the federal circuit. Now I think it's taking over a year and a half. So, that is problematic, I think, if you're a patent owner trying to kind of grapple with what's going to happen to my judgment, right? And the way that the federal circuit cases have played out, finality means there is nothing left to do but to execute on that judgment. So, finality is challenging to obtain unless you just get a carte blanche affirmance by the federal circuit.
Now, so I will throw out, and this was a topic we were going to talk about, the ITC is an interesting angle to this because the ITC's ruling won't change until there's final judgment of invalidity, right? So the ITC is a good venue for a patent owner if you can prove DI and that's the kind of relief that you really value. That's a great way to go where it doesn't really matter what happens at the federal circuit because it's going to be 2.5 years from the filing of the IPR before you even get to the appellate papers being filed. So that is a venue too where if clients are looking for injunctive relief, I think it's probably a little easier now than it was a couple of years ago to show DI, and that's a really useful tool for plaintiffs, for patent owners to use, in part because it doesn't really matter what happens at the patent office. Your ITC case is going to go to the commission, it'll go through review, presidential review, and you'll get your relief, and it'll stick until there's a final judgment of invalidity after a PTAB proceeding.
And I think back to Fintiv, we'll see what happens with the ITC and Fintiv under the new director too. So that could be another boon for ITC practice potentially.
There's a case that went up to the federal circuit, actually 2 cases, one from the PTAB and then one from the district court. It's Crimar Systems versus Ale. And it just so happened that both appeals went up to the federal circuit at the same time. So the federal circuit heard both cases on the same day. And then they decided the PTAB case first and then applied the collateral estoppel against the district court case. So for petitioners, the takeaway here is get your appeals to the federal circuit at the same time, hoping that those appeals will be consolidated or run in parallel. If you're a patent owner, keep them as separate as possible and try and get a final judgment from the district court before the PTAB issues its final written decision.
Well, and that's one of the biggest problems with the state practice these days. Like, you can't, sometimes a patent owner can't do that, right? I mean, that's the goal, but
Yeah.
if you're not in Texas or, you know, or somewhere where they'll not stay the case, you're in trouble. I mean, if the courts are going to stay the case and wait for the PTAB to do their thing, that's a really problematic spot for a patent owner to be.
Yeah. And I mean, your J-Mall could sit for a while.
Sure.
There's a lot of different things that
Sure.
could happen. You get the verdict, and then the judge gets busy and isn't thinking, well, boy, we've got to race to the federal circuit.
Right,
and need to help
right.
out. They might sit on J-Mall for a while.
We had a case where there was a stay motion. The petitioner filed the patent, the IPR on the last statutory day. There was a stay motion in District of Colorado, which is not a big patent venue, and the court denied the stay motion just recently. Has not set a trial. Has not ruled on summary judgment motions. We don't know what's going to happen. So it's great that we got the stay motion denied, but nothing's happening, right? So it's like, effectively, it is still stayed. So to me, it's very venue specific.
So the number one thing in my mind that drives costs up with these parallel proceedings is the nature of the timing of everything. And if you think about the common district court complaint, it says, the plaintiff says, defendant, you infringe at least claim one of each of the following patents. And over time, that case in the district court, you will have a narrowing of the number of patents and a narrowing of the number of claims. But that narrowing always happens after the one-year statutory bar for filing petitions. And because of that, people have to challenge more claims, they have to file more petitions, and they don't have that narrowing before they have the insight. The famous case is Windy City versus, was it Google or Facebook? I forget which. There were 4 patents and 800 claims, and you know, the petitioner took a shot at what claims they thought were going to go forward, and ultimately those were not the claims that went forward. They relied on other claims. Guys, I'll let you jump in here, and maybe
Yeah.
Cook, you can start us
I
off.
mean, I think if you want a patent owner to narrow earlier, you need to do a good job on your invalidity contentions and get them out quickly. I mean, I know it can take a long time, but I've been in cases where people want you to narrow up front as a patent owner, but you don't even have their invalidity contentions, and so that doesn't seem fair. So I think if a petitioner really wants that narrowing, you could try to push faster than you might otherwise would when you're sued, to make it an argument that, hey, you've got my invalidity contentions, you've got my non-infringement contentions, what else do you need to narrow? Claim construction is the obvious answer. But it could at least give you an argument for the court anyway if you want to push for early narrowing, which I've seen at least Judge Connolly do in Delaware. I think he has a standing order on that for ANDA cases at least. So.
Ben?
Yeah, I mean, I from my perspective, there aren't that, and again, this is just my perspective, there aren't that many cases that I've been involved with recently where the defendant didn't know the patent case was coming. In my experience, a lot of times, you know, you're talking about a license, patent owners would rather try to license the patents before they file the lawsuit. And in my experience, at least, the sort of the charts that you provide as the licensing charts are pretty fulsome because you want to scare the defendant, right? So I think that there definitely are times where there's more evidence than just the complaint saying at least claim one. I think a lot of times the defendant has an idea about what the claims might be. But also, as a plaintiff, I'm going to have to narrow my case too. I don't have a problem with a defendant having to pick and choose what they're going to do. If you want to challenge my patents in an IPR, you can do it. If you're going to do it early and try to avoid whatever Fintiv issues there might be, there's risk to that, right? There's some risk to, like, don't challenge all the claims, and if you think that you might be infringing a claim where I have a Rule 11 basis to assert that claim, you should probably challenge it. You know, to me, as a plaintiff, there's a certain amount of get your act together, figure out what claims you might be infringing, and challenge those claims. And if you're not infringing them, you're going to win that issue at some point down the road, or I might not have a Rule 11 basis to assert them. So I again, as a plaintiff, I don't mind defendants having to narrow their cases or sort of get their cases in order and have an honest look at what the liability issues are. That might have been a different answer 2 years ago when I was at a law firm defending, big companies all the time. But that as a plaintiff, I don't mind the idea that the people who I'm accusing of infringement have to pick what the fight is going to be.
Yeah, I think the answer to this question as to whether you're going to get clarity and how is going to depend on the district, right? So, districts with local patent rules and standing orders on reducing claims, you know what that's going to look like. Most of my clients are looking at, could they assert this claim at the time we're drafting the petition, just like you said.
Yep.
Right? Because, and you may end up challenging claims that you have no interest ultimately in challenging because they don't end up being asserted in litigation. I think the more difficult thing is when those claims, you looked at the claims and then you get an assertion that perhaps is a stretch of the claims just to avoid your petition and to be able to give that one claim not challenged look to the district court judge. And that, I think that's just very difficult to deal with. I don't know that there is a way to force patent owners to show their hand earlier. Of course, if you're a defendant, get your discovery out, right, and say it's been in the plaintiff's hands all this time, and if they try to expand the case beyond what they originally disclosed, you have at least some grounds to fight that. But if you're going to slow walk your discovery out the door, I think you're basically shooting yourself in the foot on any kind of argument along those lines.
Also, plug for ex parte re-exam. I mean, you could do that just before trial, when you know what the trial claims are. I mean, you could file that petition and have that kind of grenade ticking time bomb there that won't go off for a while, but that is a thing that is available, and I have seen success with, sort of late ex parte re-exam that just is out there. It's an issue that might hurt the plaintiff later. And as a defendant, you could do it when you know exactly what the trial claims are and what the claim construction is and sort of the exact theories of infringement. So that's another thing, too, that I came to it more at the end of my time at the law firm, but I think it is a useful tool to keep in mind. It's certainly cheaper, and it's certainly something that, it can be scary as a patent owner. You never know what the examiners are going to do. It's different than a PTAB panel.
Well, guys, we're a minute and a half over right now. We have an hour more of material to cover. Last word. Ben?
No, I just said at least an hour more.
Yeah. No, last words to everyone.
Again, as a patent owner, I like the certainty of a defendant infringer having to figure out their case. I think if the efficiency of the PTAB is going to be realized the way that it was envisioned, it's in people narrowing their claims, narrowing their case, narrowing their theories, their defenses earlier rather than later.
I think that, both parties just need to understand that when you throw a PTAB proceeding on the table with parallel litigation, you're going to have more complex issues coming up unless you work together with the other side on a way to streamline the case.
Yeah, I know I'm not setting the world on fire with this take, but obviously Fintiv is going to be a very interesting issue for parallel proceedings over the next couple months.
And I just want predictability so I can advise my clients.
Well, great. Well, thank you very much, everyone. That was a great conversation.